So in the previous lesson, we discussed some of the jurisprudential theories which were associated closely with that of HLA Hart. We talked about some of the general rules and implications of Hart's jurisprudence, which is a more modern, up-to-date version of legal positivism, where Hart essentially makes a delineation between what he describes as primary rules, which are the rules of law which essentially are required for the operationalization of society, and then the various different secondary rules which relate to those primary rules. This lesson is going to talk about the critiques that have been levied against HLA Hart by the philosopher Ronald Dworkin. We'll talk about Dworkin in terms of his career as a philosopher, as a jurisprudential theorist, and then we'll start to talk about the application of Dworkin's jurisprudence to that of essentially critiquing some of the more modern theories and modern forms of legal positivism. So this is essentially Dworkin's critique of legal positivism, and really we are talking mainly about the debates that were had between Hart and Dworkin around the philosophy of law and essentially jurisprudential ideas. So, like I said, beginning first, then we'll talk about essentially the career of Ronald Dworkin as a philosopher, as a legal philosopher, and as a jurisprudential theorist. He was a legal theorist who lived between 1931 and 2013. He was a professor of law and philosophy at NYU and then also at UCL University. So these are two relatively prestigious universities in the United States. And he was also the chair of jurisprudence at the University of Oxford, which is, of course, a very prestigious position within the University of Oxford. His philosophical influence can really be situated in the times in which he was doing his philosophy. So people like Hart were writing at the time that Dworkin was writing, but then if you look at philosophers from other different philosophical disciplines, people like Quine, they were also quite influential. Of course, Quine was more influential in terms of his development of modal logic, his development of metaphysics, and also his development on the philosophy of language, all of which we have lessons on in and over on the Philosophy Academy YouTube channel, where we're actually at the moment, at the time of recording at least, talking about and discussing Quine's theories of ontological commitments. So we describe a lot of the work pertaining to Dworkin as something of a response to the legal positivism of HLA Hart, because essentially you can't really detach the two from each other, because Dworkin's development of his own theories of law and jurisprudence were that of a response to people like HLA Hart. And so the back and forth debate that was had between these two philosophers, which was in some cases actually a debate that was back and forth, were essentially allowing for us to intertwine these two philosophers, such that you can't really talk about Hart without really referencing Dworkin, and you can't reference Dworkin without talking about Hart. So with that being said then, if you haven't seen our video on legal positivism from the perspective of HLA Hart and the modern forms of positivism, then I would highly recommend you go and look at that first. It will be in order in the playlist. But let's just do a recap of Hart's legal positivism. So what Hart does is describe law as a set of rules, okay? And we remember that this is something where we see a detachment from morality, which is, of course, how Hart delineates himself as a positivist, away from the natural law theories that were beginning to wane in terms of their popularity. According to Hart's concept of law, he says that the rule of recognition providing the criteria by which the validity of other rules of the system is assessed as an ultimate rule, and where there are several criteria ranked in order, or relative subordination and primacy of one of them is supreme. This is his explanation of what he describes as the rule of recognition, which is described and defined as one of the major secondary rules of Hart's jurisprudence. If you remember, we're talking about rules of adjudication, for example, rules of change, i.e. in order for a primary rule to be a law, it ought to have the ability to change and be reformed to better reflect societal standards. Adjudication refers to the idea that law, in order for it to a rule for it, in order for a rule, sorry, to be law, it should have the ability to, or there should be some mechanism by which an individual can actually go about and adjudicate on the disputes arising out of those laws. And then you also have this idea that is recognized in this passage here, which is of course the rule of recognition. So what Dworkin does is he begins by critiquing the positivist conception that law contains rules and that law can be represented as a set of rules. And because the reason for this is because, according to Dworkin, law can also contain non-rule standards. So to suggest that law is just a collection of rules and law is best to be perceived as rules is something that Dworkin critiques, and he essentially issues a counterexample to this particular conception, arguing that, okay, well, if that's the case, then why does law contain non-rule standards? So therefore, as a result of which, you would conclude that Hart's legal positivism is incomplete, or it is lacking in some way. What Dworkin does then in building his conception is that, firstly, recognizing that law contains non-rule standards, first of all, but then suggesting that these non-rule standards could be considered to be principles. So the existence of these principles are not necessarily to advance some kind of socio-political or economic end goal. Remember, the word telos is just a translation of ancient Greek for the word end. When we talk about something having a teleology or having a telos, we're talking about the end goal. So when we think about the Aristotelian influences on natural law that we did earlier on in this series of lessons, we talked about the fact that Aristotle was very teleological in his perspectives of law, or at least his perspectives of rules, and actually his perspective of morality more generally. And so the existence of principles, when it comes to Dworkin's conception, is not to advance some kind of end goal, some kind of socio-political end, but rather to fulfill some requirement of justice or fairness, i.e., or some other dimension of morality. So really, in this sense, the telos of a particular legal principle is not relevant in terms of what Dworkin would describe as these principles. Rather, the point of it is the idea and the requirement of justice or fairness itself. What happens here is that Dworkin will discuss a number of cases which illustrate this point. And one of the very, very key cases that is very interesting in this regard, that illustrates this point perfectly, is the case from 1889 of Riggs and Palmer. Ultimately, the defendant in this case murdered the testator of an estate. Remember, or for anybody who has not studied the law of trusts, a testator is a person who will transfer legal title in the creation of a trust. A testator is dead, and the settler would be somebody who is alive who creates a trust. So the settler and the testator are the same person, but we define them as a settler or a testator depending on whether or not they're dead or alive. Now, the interesting thing here was that the estate was due to be inherited by the murderer upon the death of the testator. So the testator had an estate, and essentially the person who was going to inherit said estate was the murderer of this particular individual, or at least more specifically, the law at the time meant that, according to the law of succession at the time, the murderer would actually have inherited the estate of the murdered person. Okay, so they may not have been directly in the estate at the time of the murder, but they would have inherited the estate upon the death of the testator. And so the law of succession meant that essentially what we have here is an individual who is a murderer who is now inheriting the state of the victim. And of course, this doesn't sit particularly well in a number of different instances. The courts held in this case that no one shall be permitted to profit by his own fraud or to acquire property of his own crime. So what this is essentially suggesting is that even though upon an ordinary understanding and reading of the law of succession in this case, the person who was the murderer should have inherited the estate, because of the fact that an individual should not have profited from their own fraud or have acquired property by their own crime. It meant that they were not going to get the estate in question. So this is an example that Dworkin uses to illustrate the fact that there are some principles that don't necessarily adhere to a rule and therefore a law as a rule, as Hart would have suggested, but rather fits certain circumstances to deliver justice or fairness in individual cases. So like Dworkin says here, he talks about the idea of there being a principle that will serve or fulfill the requirement of some other dimension of morality. And he uses this example here of the case of Riggs and Palmer to illustrate this point, essentially. Dworkin then argues that this is how a principle operates, essentially. He says that a principle should be able to override an established rule, that is a legal rule. Because if we go back to this case of Riggs and Palmer, the established legal rule of the law of succession was that the murderer would have actually inherited the estate of the victim, and so therefore would have killed the person and would have gotten all this person's money and been very, very happy probably. And so as a result of this, that is the rule, but the courts overruled that rule, essentially. They said that this would override the established rule, and that's what Dworkin argues is a principle. The difference between legal rules and legal principles is actually one, according to Dworkin, of a logical distinction. They can both point to particular decisions about legal obligations, but what they will do is differ in their character. So legal principles, as we've mentioned, aim to achieve justice or fairness or other moral dimensions without consideration necessarily for the teleological perspective of society, the teleological end goal, whether that be socio-economic or political. Continuing then and going back to Hart's principles of jurisprudence, we have to think about the concept of the rule of recognition, which is one that Hart develops, but also one that Dworkin will reject. He rejects the notion that there exists some kind of mass rule in every legal system that is utilized to identify the validity of law, which is what the rule of recognition is. And if you want to know more, go back to the previous lesson. And the reason why he comes to this conclusion is because the idea of a rule of recognition would actually lead to a situation where we actually develop a process of identifying law, but we have to think about this as something which would be of relative ease. And so he rejects this view. He rejects the idea of the rule of recognition entailing that the process of identifying law must be an easy process. Actually, Dworkin argues that people still have legal rights even in cases where the correct legal outcome is disputed. So whereas Hart would suggest that according to the rule of recognition, we should be able to identify law within a particular situation with relative ease, and bear in mind that is not just recognizing that a thing is law, that for example, if Parliament passes legislation that is law, but talking about legal judgments in adjudicative cases. So even where the correct legal outcome is disputed in those situations, some of the really complicated and difficult and often heavily critiqued situations, Dworkin suggests that, if we were to follow the rule of recognition by Hart, then this would be a difficult thing to reconcile. But according to Dworkin, those people still have legal rights. The law exists somewhere in this particular set of circumstances, and this is the case even where the correct legal outcome is disputed. Finally, then, I just want to talk a little bit about the interrelationship between law and morality, something that we have really been coming back to as a major theme throughout this series of lessons, specifically looking at when we talk about positivism. Well, this is one of the areas where Dworkin actually agrees to an extent with the writings of H.L.A. Hart. He argues against the view that law and morality are to be completely separate. Okay, and what he does is cite a constructive interpretation of the law and suggest that this constructive interpretation of the law must necessarily implicate moral judgments when it comes to decisions about what the law is and what the law isn't. So again, when I say that a positivist can develop a theory of law which does give rise to considerations of morality, this is not suggesting that legal positivism, or at least these theories of legal positivisms, can be reduced to natural law, because what natural law does is place morality front and center and suggests that it is morality, or the moral law, from which all legal principles derive out of. A legal positivist doesn't believe that, but a legal positivist doesn't necessarily mean that you have to disregard and have no interconnection between law and morality whatsoever, because you can have law and morality having some kind of relationship with each other and still be a legal positivist. And that's really what Dworkin, and as does Hart also, suggest when they develop their theories of law.